now 6 p.m. and I will call to order the special board meeting of the Lost Pine Groundwater Conservation District at 6 p.m. in the Bastrop City Hall, 1311 Chestnut Street, Bastrop, Texas. We have a number of people in the audience tonight. Thank you for taking time out to attend our special meeting and observe the affairs of the groundwater district. This is a one-item agenda tonight. This is item number 3 of the agenda. Consideration and possible action on the application for operating and transport permits filed by NDOT LP. I believe Mr. Craig Ellis would like to report to the board at this time.
Mr. President, I will recuse myself over there. Thank you, Mr. President. Members? Is this on?
I don't think so.
I'll skip that. Mr. President, members, thank you very much for your time and attention. There are several ways that we can proceed tonight, but I want to report to you that the NDOT company has presented to us a settlement proposal that I would like you to consider. Dave, can we get these? Or Jim, can we get these handed down? Board. Yes. The two documents you're getting, the first one is the settlement outline. The second one is a brief that was provided to us earlier today, I think, or maybe yesterday, on the question of how far you can go in changing the proposal for decision from an administrative law judge. If we get to that point, that's certainly going to be good information for you to consider as well. What I'd like to do is lay out the settlement agreement. If we need to go into executive session to discuss some of this, we can, we have that option. And certainly you're welcome to deliberate this as much as you need to. This is made as an offer of settlement and therefore is not going to be part of the official record. This would not be part of any decision that you make. If we end up not agreeing to the settlement, it doesn't become part of your decision or the record on the decision later on the permit. I want to make that absolutely clear. The sticking point on this application, of course, is that this is a large amount of water to be produced. And the goal of the district, of course, is to achieve its desired future condition and ensure that no harm is done to the aquifer from this or any other permit that's issued. So in furtherance of that goal, what this settlement has offered up, instead of a single permit for X amount of groundwater, is a multi-tiered approach. The first permit, first authorization would be for 25,000 acre feet per year. Once they have actually produced 12,500 acre feet for 2 consecutive years, then we would run tests, we would run the models, we would look at the actual impact to the aquifer levels from that pumping, from a monitoring system designed to isolate and understand the difference between what's happening to the aquifer generally and what's happening from this applicant's operations. And if the actual pumping is less than the amount that we had modeled, if it's less than what we had predicted and an amount that will achieve the desired future condition, they would then be allowed to go on to produce tier 2.
Pumping, you mean drop down, right?
I'm sorry?
You said pumping, you mean drop down, right?
Well, achieve the desired future condition is a drawdown number. That's correct. But it would be based on actual pumping, not on modeled numbers, not on predicted numbers. If they achieve that threshold, they could then go on to the second level of pumping. The second level of pumping would be 36,000 acre feet. At that point, as soon as they were producing 18,000 acre feet of groundwater for a period of 3 consecutive years, we run the tests again, and we determine whether or not they're still going to be able to achieve what the model said they should be achieving, and the district can consider whether or not we can still achieve the desired future condition. Again, we're looking at and comparing actual production and actual aquifer levels as opposed to modeled results. If they are achieving it, they would then go on to the full amount of permit, which is the amount the administrative law judge has recommended, the 46,000 acre feet. If they're not achieving it, then they would stop where they're at. If at any point the general manager and the permittee disagree on what these test results show, that matter would go to contested case hearing. That proposal for decision would come back to this board for a final determination. The board gets the final say as to whether or not the test results show that they've achieved what we expected them to achieve. In addition to those pumping numbers, we have a condition for every level of production that they have to have a contract in hand for delivery of the authorized production amount. In other words, they can't pump without a contract for a final end user for that water. NDOT has agreed to pay for a mutually agreeable monitoring well system that would be placed wherever the district and NDOT agree the monitoring wells need to be placed. They would be jointly monitored by the district and by NDOT. And monitoring would have to occur, of course, at consistent, mutually agreed upon time intervals. We would come up with mutually agreeable measurements for determining whether the actual drawdowns are less than the model's drawdowns, and I'm going to add this sentence to the document that you have there. At the end of that, the word drawdown, please add the following. And the actual groundwater production on a long-term basis will not prevent achieving the desired future condition. And that's a key consideration from 361083 on issuing any permits. You have to issue permits on the basis that the district will be able to achieve its desired future condition. 3, they have to have binding contracts for delivery of water, and those contracts must be produced by NDOT to the district within 5 years of the district granting the initial permit. We're removing the time limit on the drilling of water wells. There's no reason for them to have to drill a water well this year that they're not going to put into production for another 6 or 8 years. And that saves them some money, which they then get to spend on the monitoring system that they're going to put into it. It also prevents more holes in the aquifer that we don't really need to have until they're absolutely necessary. I covered 5 and 6 on the disputes. 7, NDOT will agree to develop, complete, and produce water from Lee County well field before beginning construction in Bastrop County. The Bastrop County well field will not be constructed until the Lee County field is at least 75% developed. Subject to satisfying the district spacing and setback requirements, NDOT requests that at least 2 wells may be relocated from the Bastrop field to the Lee field if that is necessary, at a location of their choosing, as long as they meet our spacing limitations. And then, well, I talked about the last part because there had been discussion about production withdrawals. If the district ends up implementing withdrawals throughout the entire district, there had been some discussion about NDOT agreeing to produce more than anyone else is required to produce. That number 9 simply makes it clear that that's coming off the table. They're not going to agree to any greater, they're not going to agree as part of the permit condition to any greater reductions than anybody else. The advantages of this, of course, are this keeps you out of the courthouse. If you agree to this, we're able to come up with a final document, we're able to come up with final permits, then they'll have agreed to it. There's no reason for them to come back and file an appeal and take you to district court to fight about this permit. A disadvantage to this, I guess, would be you are issuing a permit ultimately for 46,000 acres, but only if they can show through actual production and actual aquifer levels that production is not going to cause harm to the district or harm to the aquifer or prevent you from achieving the desired future condition. So I think that this is a good compromise. I'm happy to answer your questions that you all have about it. Jim, do you want to make a recommendation on this, or do you, I know we kind of swung it on you today.
Not at this point.
Okay, so, and I have not heard from Mr. Gershon or Aqua, is my public hearing then? I don't believe they have any objection to this either. I think y'all have had a conversation, so I don't think there's any objection from Aqua. They're a party to this, so they would have to agree to this as well. Mr. Seiler?
I'm confused about the 75% developed in number 7.
Yes, sir.
What is that 75% of what? Is that 46,000?
75% of the amount that they're planning, the total amount they're planning to produce from Lee County. I think if they,
So that's-
if they were to produce the entire 46,000,
I don't know, he came on later and I don't think he's aware of the Aqua settlement.
okay, right. Aqua was a party to this contested case. In order to get their participation somewhat neutralized and not agree to certain conditions on their permit with Aqua. One of those conditions is only a certain amount of production can occur in Bastrop County. So I think if the permit's a total of 46,000 acre feet, then no more than 16,000 acre feet could be produced from Bastrop. The rest would have to be produced from land. That's an agreement between those parties. It's not really a condition on the permit, that's just their agreement. Now this part, where they're talking about the 75%, what we're saying there is if we're looking at producing 30,000 acre feet from Lee County, they would have to be actually producing 22,000 acre feet, I can't even up that quickly, before they could begin to work on and produce and develop the Bastrop field.
So I think what this is saying is, it's for 46,000 acre feet is what the overall top number is. So you'll have to get to, what is 75% of 50,000 acre feet?
No, it's going to be 75% of just of what they're planning on producing in Lee County, which would be,
Well, that would still be 30-some
that'd
thousand.
be 30,000 acre feet. So the Lee County production overall, if it's 46,000 acre feet, and again, I want to reiterate, they don't get to 46,000 acre feet without passing at least 2 separate sets of aquifer tests.
Okay.
Assuming 46,000 acre feet, 30,000 of that would come from Lee County, so it would be 75%.
Before they could ever do
that-
anything in Bastrop County.
Right.
I think it's 22 fat, Greg.
Sorry?
I think it's 22 fat.
22
$72.5 of 30,000 acre feet per year. Where are you getting the 30,000 acre feet per year?
I think that's what they produce out of Lee County.
Right, the Aqua agreement limits them to 16,000 acre feet in Bastrop County.
Oh, so
and
you're
the other
taking
30,000 would come from
okay,
Lee County.
okay, I see, I'm getting there, okay.
And I want to reiterate, that's only if they get to that point. They have to pass 2 tests
Okay.
to get to 46.
Item number 3 there regarding delivery water we produce to the district within 5 years of, I'm sorry.
That's like they have to have binding contracts delivered to the district, and those contracts have to be presented within 5 years after the permit's issued.
And what happens if they are not able to produce those binding contracts in 5 years?
I think that means that they're going to be limited to where they have binding contracts. They cannot produce more than they have binding contracts to produce.
So just hypothetically, in the 5-year time frame, they submit to the district at the end of the 5th year, 27,500 acre feet of water under contract. That's all they're going to be able to produce.
Then that would then become their limit. Now, again, because that's more than the 25,000, they have to pass the test. When they pass 25, but yes, they're always going to be limited to what they have contracts to produce.
So how will they ever get to the 46,000 acre feet then? Because at 5 years, that's when this ends. The max they can produce at the end of 5 years is 36,000 acre feet by what we're looking at here. So that's all they can have
If
contracts for.
they don't have contracts in hand to produce the water, they have no authority to produce it.
Yeah, so they'll get contracts for 46,000 at the end of 5
If
years,
they can get
even though
contracts
they
for
can't produce
46,000,
it.
and they
and then
pass
we'll
those
have to
tests
do a
on those
permit.
tiers, then they can produce the 46,000.
And then we'll have to turn it.
Do you all need to have an executive session to ask any questions? Yes, sir? Yes, sir?
As I read this, they would be permitted 25,000 acre feet, but they only have to produce half of that.
They have to produce a minimum of half of that in order to be able to stress the aquifer enough to test it in order to be able to move on to the next year. That's correct.
So if they produced half of that, they would only have half of the effect on the aquifer.
Well, that would have to be factored
To
in.
the next level.
Yes, sir, that would have to be factored in. I mean, we're not gonna say, did you meet your goal for producing 25,000 acre feet when you only produce 12,500? That doesn't make any sense. And that's part of the detail that we're gonna have to flesh out. If the board chooses to do this, the appropriate motion would be to agree to these settlement terms, subject to special counsel, general counsel, and the applicant finalizing the settlement document and associated permits for a final board vote. So tonight's vote would not be the final say on this. You'd be able to review the final documents. If there's anything in the final documents you don't like, you can try and change them. They either agree to it or they don't. They don't agree to it, we're back where we are right now, and they're going to vote on their permit. If the board, if we present to you documents you can't agree with, then you have a chance to vote and approve the permit that night. The goal would be to get this done and back to you in time for your October board meeting.
Greg, I will say that I'll have a concern if they're producing 19,000 acre feet per year at the end of 5 years. I'll be concerned to then ground them a 46,000 acre foot per year permit. Based on they're pumping 19,000, that's half of 36,000, so they need to get to 46,000 acre feet. Because that's another, that's another huge jump.
I agree with that, and that certainly is a concern. The problem is, number one, they have to have some time and ability to make an adjustment. They can't be producing 100% of their authorized amount for some period of time. There has to be some pre-work in there. And we really don't want to do anything to require them to produce a huge, the maximum amount from the aquifer.
Right, I understand.
We want enough to
Yes.
stress the aquifer and be able to tell whether or not our models are right or wrong on predicting what's going to happen when they do that stress. At the same time, we don't want to say you have to produce at least 25,000 acre feet, because then it forces them to do that.
Right,
So
I understand.
I think this is a good middle ground to find a way to stress the aquifer enough to test it
Right.
and be able to move on to the next level.
Good. Any other board members, any questions? Would the board desire to adjourn into executive sessions and any other discussions with legal counsel as it legally pertains to the settlement agreement?
I saw at least one yes.
Yes.
Okay. We are posted for an executive session, so at this time, the board will recess into executive session to consult with its attorney regarding any posted matter in which the board may seek the advice of its attorney under Government Code 551.071 for any action on the agenda for which a closed session is permitted by law, and will reconvene an open session for appropriate action on any matter considered in executive session. We are going into agenda executive session for item number 3 to discuss with legal counsel the application for operating and transfer permits as filed by NDOT LP. The time is 6:20 p.m., so we're adjourning at 6:20 p.m. into executive session. and we can go back and back there. You know, stay on. It is now 6:50 PM. We come out of executive session. I'll take us back into regular session. In the executive session, we discussed and reviewed the legal ramifications of the settlement offer read to us by our special counsel to give us a better understanding of what has been presented to us by the board. At this time, I will.
We still got 2 board members.
Didn't give him credit.
Full board. Like I said, we reviewed this document with our legal counsel and understood the legal ramifications of what is played before us. And so at this time, I will entertain a motion from the board.
Mr. Chairman, subject to working out of the details, but it's going to have to be to get the document in the permit form, contract form. And looking at what we're charged with, protecting the aquifer and restricting water where needed, as needed. I think that this is a reasonable settlement, and I do make a motion that it be accepted and approved.
I second that motion.
Okay, we have a motion and a second to approve the settlement agreement that has been presented to us by Mr. Greg Ellis, our special counsel. As Mr. Semaine mentioned in his discussion of the motion, these terms now have to be put into a contract for us to review. Would you all consider amending your motion to include that Mr. Ellis will work in putting this into the document form on behalf of the board, since we've been working with him on this issue since the beginning?
I have no problem with that, because he's going to have to work with general government. He's going to have to work with in-house counsel to get it found out.
Then I do have a motion and a second that we accept the settlement offer and to us by Mr. Greg Ellis from PennDOT, and that Mr. Ellis will coordinate getting this into a contract document. Is there any other questions from the board? I would just like to say thank you to Mr. Ellis and thank you to PennDOT to work with the board, and appreciate everyone's effort in putting this offer before the board, and so that we can move forward. With that being said, all those in favor? Opposed?
Aye.
The motion carries, and we will commence putting this deal sheet into the contract, and I'm sure the attorney will be keeping us posted. And thank everyone tonight for your attendance, and everyone for the effort that was put forward. Thank you. We are adjourned.